majority community in East Bengal, in East Pakistan was not willing to stay there.
Maybe substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
Again, if you go
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported.
My learned friends have argued on 2-3 counts. Number one, they say that their cultural rights under 21 have been impacted by this demographic change. That's one. Number two, that Article 14 has been violated for the reason that while this protection is given to migrated people in Assam, it's not given to others. And number three, they say that Section 5 and 6 are frozen in time in the Constitution. Article 5 and 6 are frozen in time. And therefore 6A cannot in fact have been enacted. Broadly speaking, these are the three broad submissions. There's a fallacy in each one of them, and I demonstrated right away. Migration of peoples and populations is embedded in history. It cannot be mapped. No migration can ever be mapped. And if you look at the history of Assam, you'll realize that it's impossible to figure out who came when. Assam originally was a part of Myanmar. And it was way back in 1824, after the British conquered a part of it, that a treaty was entered into by which Assam was handed over to the British. And I'm talking about 1826, 1824, 1826. You can imagine the kind of movements of peoples that must have taken place in the context of the then British Empire. And if you jump to 1905, you will have the partition of Bengal. And in the partition of Bengal, East Bengal and Assam became one. Indeed, at that point in time, Bengali language was forced to be taught in schools. There was a huge opposition to that. So this interaction between the Ahom people, who are the original inhabitants of that part of Assam that was taken away from Myanmar, integrated with the non-Ahom peoples. And therefore, the interaction and the absorption of the Bengali population in Assam has a historical context. In 1911, Manoj, it was reversed. The partition of Bengal was reversed. But they belong to the same area. The ethnicity was different. The language was different. And all these problems were created by the British. Because when the independence of India took place, East Pakistan, which is now Bangladesh, was carved into a separate country. And the exodus happened because of the fact that the ethnic minorities, linguistic minorities, as well as the majority community in East Bengal, in East Pakistan was not willing to stay there. The problem on the West Coast was entirely different. On the Western border was entirely different. Because on the Western border, it was the Hindus who were coming into India, not the Muslims. The Muslims were given the choice to go there. That's why the date 19th of July.
Constitution presupposes by postulating Article 19(1)d. You rightly said that, there's free movement. But this applies within the nation.
I agree. But let's kindly see 29 now.
Can the people of a state not say, suppose the union were to say that we are going to resettle, say 20,000 refugees or 25,000 refugees in a particular state. There may be substance in the argument, we may not accept it, but they can certainly found a constitutional challenge.
But I'll answer that. See 29.
You cannot have a challenge at all.
Well, that's 29. Just look at 29. 1984, Rajiv Gandhi then said, let's try and compromise this issue. In the meantime, Praful Mahanta became the chief minister. And in the 2 years, 83 to 85, they got discredited. The movement, became weak. And the 85 Accord. Mrs. Gandhi always said, let's keep 1967 as the cutoff date. The learned solicitor rightly said, because of the 66 electoral vote. And 67 was the election. They did not agree at that point in time. But in 1985, when Rajiv came to power, he said, no, there should be give and take. And therefore, this cutoff date was agreed to. And therefore, the 1966 to 1971 period was dealt with separately. And the other period was dealt with separately. That's the genesis. Now, the first submission that my learned friend gave, he gave you population figures, those figures cannot possibly be relied upon one way or the other. Because you don't know the genesis of the migration. And even their figures show that after 71, the Muslim population has been reduced. Therefore, yes, the rate of growth has been reduced. So the point I'm making is I'm on the first point, of the Article 29 point. That has no constitutional basis. This to happen, and then makes a provision for it under the law. And there's no basis for challenging it, other than the ground that it is discriminatory. But this was a non-discriminatory recognition. Not based on sex, not based on race, not based on caste, not based on religion, not based on on no prohibited...
Place of residence, yes.
Sorry?
Based on place of residence.
No.
You have to be an ordinary resident of Assam.
No, but that's the test. That's the test, I'm sorry. That is the test. That test was applied between 66 and 71. And as a matter of constitutional law, and again, if you go...
So you will have people in India who have been otherwise recognized as foreigners by the Foreigners Tribunal's order, who cannot be granted Indian citizenship, and yet who cannot be deported, though they are aliens.
That's correct. And this creates more problems for India, as your Lordship said, because after 1971, what will happen? Children would have been born here. Can your Lordships imagine the enormity of the problem? Those children born here would seek protection of 3. Where will they go? So that's, I don't want to enter into that. It's another area altogether. So that takes care.
Equally, there is substance in this grievance that, on the one hand, we don't have an open border.
Yes.
We do not say that anybody from Bangladesh can come and settle down wherever they want to in India. At the same time, if we don't take action to curb illegal migration, then it causes all these problems in India. The feeling in India that, look, the infrastructure is limited.
Absolutely.
Education is limited.
Absolutely.
Public hospitals are limited. We can't allow for an unlimited influx.
Absolutely. No, you're right. And this is the problem.
Therefore, we passed that order, which we did this afternoon. What are you doing today?
It's the executive that is to blame, There's no doubt about it. And right from 85. And we create problems for ourselves. And then what happens is, it becomes the other versus us. This is the heart of the problem. It is no longer a cultural issue. It's a political issue. Others versus us. Who gets power? Why do you give them electoral rights? This is the problem. Don't give them the right to vote. So therefore, you, in the process, are creating divisions in society whereas your preamble talks about fraternity. Now, what is fraternity, Millard? Live and let live is Article 21. Be and let be is secularism. That's what it is. And that's fraternity. And the entire argument on the other side is countering the concept of fraternity in the preamble.
So, Sibal, how do you, I mean, this is not a question in the sense to tell you that you're wrong on this point, but just a little assistance. How do we sort of conceptualize subsection 2 of section 6A and subsection 3?
All right.
Subsection 2 deals with people who are in the electoral roll as on 1/1/1966.
Right.
They're all post-1951 people,
right,
but who are in the electoral roll as of 1/1/66. Right. That's why subsection 2 refers to the electoral roll of 1/1/66, 66 electoral roll.
Right.
The subsection 3 covers people who are not in the electoral roll of 1966.
Correct.
They came in later until 71.
Correct.
So what was the reason for protecting those whom they protected first in subsection 2? Was it that Parliament wanted to protect people who are, now they've come on the electoral roll as on 1/1/66, so we say, all right, you have now been assimilated. We have already, whether you are legal, illegal, we sort of make a blanket conferment of citizenship. What was why these two bifurcations into subsection 2 and subsection 3?
I will try and answer that, Malad. There are two reasons for it. Number one, even those whose names were in the electoral roll, people objected to them. People objected to them, saying they got themselves into the electoral roll. They did not come here prior to 1966. That's why the whole NRC exercise has taken place. And at the end of the NRC exercise, do you know what the result is? Your Lordship asked that question, they should have told you the answer. The answer is, today there are 19.06 lakh people who are left out of and whose appeals are pending. That's all. And the majority of them are Hindus. So it's not as if nothing happened after 71. This exercise has been done and done in 8 years, Maharaj. Maharaj, that's why Justice Gogoi said, everybody will have to produce the legacy tree, legacy data. Who was your great-grandfather? Even those whose names were on the electoral roll. So in the NRC, every citizen, every person in Assam had to face the test. So in fact, from a statutory standpoint, what my lord is saying is right. From the actual standpoint, it's just the other way around. Because there were thousands of objections. Well, somebody didn't have a school certificate. Well, who gave a school certificate at that point in time? Then you had to show, no, my great-grandfather lived in that village. Then there had to be a linkage document. Then you had to produce somebody from a nearby village or the village in which you lived, and he came and made a statement, no, his grandfather was living there. So, Malaj, it may be as a matter of law for you to say that's not factually correct. Well, the whole NRC exercise was that all this may be wrong.